So, parental alienation has been a bit of a catch-cry in the family law jurisdiction in recent years, with limited research and understanding into the intricacies of what it really is and how it impacts on families and children long term. Not indifferent to other forms of abuse, the true extent of it is yet to truly come to the surface, with many non-alienating parents being either unaware of this being behind their children no longer wishing to see them, or very similarly to many cases of domestic abuse, it becomes so normalised in the relationship dynamic that the non-alienating parent has doubt over whether it's happening or if it's all in their head. Often the only way to gather clear evidence that parental alienation is occurring is to commence court proceedings and bring other professionals and experts into the picture, with a court ordering appropriate assessments be made. For most of us, however, we are left resigned to circumstances that could only possibly have come about by way of parental alienation, but with little evidence to support it. Very much like many survivors of domestic abuse characterised by coercive control. So I'm going to paraphrase a lot of this. A decision was handed down on the 27th of August of this year in the Family Court of Australia here in Brisbane, and it was regarding the parenting arrangements for a 12-year-old child. And the mother in this case had alleged that the father had sexually abused this child and posed a risk of ongoing sexual abuse to his daughter. It was based on historical allegations against him by a much older child of his back in the early 1980s. And the mother had gathered supporting evidence, which were recordings of her daughter saying things that supported the allegations of sexual abuse, but it sounded very much primed or coached, as though the mum had specifically gathered this information to support her case. One way or another, family reports considered that the mother had failed to maintain the appropriate boundaries as a parent. She had brought the child into the parental conflict, and it was effectively tantamount to child abuse. The report writer considered that it was psychological abuse of the child, both at the time and would have long-term and lasting psychological impacts, and the court considered it to be emotional abuse of the child. It had gone as far as to cause the child to be so fearful of the father that she refused to see him, and when she had seen him, she had run away from him. So, in short, Her Honour made orders that the child live with the mother and didn't provide any time for the father, although she didn't restrict him from having contact, but it would just be on the basis of when the child would actually wish to see him. It didn't matter, she refused to see him. But if she wanted to in the future, there was no restriction on the father. So Her Honour recognised that this was a case of serious emotional abuse of the child by the mother, but that to remove the child from the mother at this time was likely to exacerbate the child's already fragile emotional state. So again, I'm paraphrasing, but the crux of the decision was that despite the clear parental alienation of the father by the mother, and despite this being tantamount to child abuse, the circumstances now placed the court in a position where the best interests of the child were met by leaving her with her abuser. And in reading it, I could feel that the court was torn in this decision, but the evidence supported the decision that was made. So, where does that leave you if you are going through this yourself? So if you're fortunate enough to have identified this while you're still having time with your children, then it's not too late to turn things around. You can potentially get the other parent involved in some form of counselling and improve the co-parenting relationship. You could look at family dispute resolution, mediation processes, and ultimately, I guess, you could potentially go and see a solicitor and look at making an application to the court and commence court proceedings around it. So you've still got sort of all those avenues that you can try, and it's not too late because the children are still coming to see you. If, like me and my husband, your child or stepchild has ceased coming over or having any contact with you, the likelihood of court proceedings exacerbating the emotional abuse the child is already suffering is very high. The parent was alienating the other parent in normal circumstances, so if you bring that parent into a situation of court proceedings, it's just going to heighten their thoughts and actions. This in turn falls on the shoulders of the children again. So depending on your personal situation, you need to weigh up whether the benefits of seeking the child live with you or spend more time with you, if the benefits of that outweigh what they're going to have to go through while that's happening. It's very difficult, and it's going to be based on your personal circumstances. So I highly, highly recommend you see your own lawyer and get your own individual tailored legal advice. Otherwise, in the position we are in, you are left with sending that child messages of love and care, and if you are prevented from doing that by the alienating parent, write letters, keep those letters, encourage extended family to reach out to the child so that they can possibly maintain those connections, if nothing else. Engage with the child's school so you can make sure that they are still progressing and they are safe and healthy and doing okay. The school could potentially assist in reconnecting you with the child when they're older, possibly. At the end of the day, you may wish to see a lawyer and get your own legal advice, but I strongly recommend getting counselling because you are going through the grief of having lost a child in these circumstances, and you shouldn't minimise that. It's a big thing, and it's a huge loss, and you need to look after yourself so that when they do come back, you're ready.